Early afternoon from my side and welcome to the first Directors Hour for 2021. For those of you that don't know me, I'm Anne-Marie van der Merwe, Executive Chair at Bullock Report, and pleased to have with me my co-host, Professor Frik Landman, CEO at the Stellenbosch Graduate Institute. As it's the first Directors Hour for 2021, and for those of you that may be new to our event, allow me and Frik maybe just very briefly, 1 minute each, to just very quickly introduce our respective businesses. And if I can pull rank, seeing that I am, so to speak, behind the podium, Frik, I'm just very quickly going to introduce the Bullock Governance Group. We call ourselves the leading independent governance firm in South Africa. We have an advisory, a COSEC, statutory and academy divisions. There's about 60 very sharp fluid rockers in our team, very passionate about ethical and well-governed corporate citizens in South Africa. And it's one of the reasons on Monday I will be spending a full day in the training directorship, and we've also partnered with the Stellenbosch Graduate Institute to actually produce a very extensive 3-week program and training on being effective directors. So I think while I'm talking about SGI, Frik, let me hand over to you for a quick slide. Thank you.
Thank you, Anne-Marie. As you've heard, I'm Frik Landman. I am the CEO of Stellenbosch Graduate Institute. It's one of a group of 2 educational entities in South Africa. Our focus specifically is on the on online and on the corporate environment and corporate education. So in more traditional terms, you could call us a business school. Our other partner, what was previously known as Pearson Institute of Higher Education, which we acquired in February, which in future will be known as EduVos, they focus more on the degrees and your normal student kind of university environment. But that's where we are, Anne-Marie, and I must say I'm glad that we've partnered with you. And these sessions every second Thursday is really adding a lot of value to a number of people's lives. And I'm very glad that we can be a contributor to that. But thank you so much.
Thank you, Frik. In the interest of my bandwidth, I'm going to keep my camera off for now. I want to really turn to our very interesting topic for today. And as some of you may already know, a review of the Companies Act of 2008 has resulted in the publication of the Companies Amendment Bill, which is currently also the subject of very intense engagements and negotiations and discussions at a NETLAC level. And as part of this process, the issue around mandatory or introducing mandatory worker participation in boardrooms as an additional to the Companies Act was put on the table and has become the subject matter of some discussion also at a BUSA level and with other interested parties from Labour side, obviously from government side. And considering the implications of this provision and these sort of proposed provisions, I mean, it goes without saying that this could be quite fundamental for and critical for South Africa and for corporate South Africa. And I think it has become very important for us to open the debate on as many platforms as we can, to have discussions around this topic, really with the objective of finding the best possible solution for South Africa in corporate. End of the day, that should be the focus for everybody, involved. And I cannot think of a better person than Professor Jean du Plessis to talk to us on this topic. As you may have seen from the registration page and our invitations, Jean is a lecturer at the professor in law at the Deakin University in Australia. I think, if I'm correct, John, has been outside of South Africa, left South Africa around about 22 years ago. He's also an extraordinary professor in law at the University of Johannesburg. Obtained his LLD at UJ many years ago in 1991 already. John was also quite involved in the whole process when the current Companies Act was under construction. But I think one of the main reasons, apart from the fact that John still speaks very beautiful Afrikaans, having been out of South Africa for so long, one of the main reasons that I thought couldn't think of a better person to talk to us on this topic is the fact that John is an academic expert. He's really studied governance structures and models all over the world, on Europe, and in particular the German structure. Very averse, very well acquainted with that structure, completely independent. He has no specific relationships with anybody in South Africa. So I really thought that John is a good, solid, independent voice of reason for us to listen to and to really gain from his very extensive and in-depth knowledge and understanding. We are also very blessed to have Professor Mervyn King on the line with us, and after Jean's presentation, I'm going to ask Mervyn to just take 2-3 minutes to share with us his views, particularly around the engagement and the topic on engagement with different stakeholders in companies. So welcome and thank you, Mervyn, for your willingness to also talk to us today. But with that, Jean, can I hand the floor to you, please, and ask you to take us through your presentation, which I know everybody is equally excited.
Thank you very much.
Today. And thanks again.
Thank you very much, Anne-Marie. Thank you very much for the kind introduction. From my end, I will just make a few opening statements and comments, and then a disclaimer, as all good lawyers normally do. And then I will take you through a few specific parts, just to give you an idea of what I will be dealing with, all very relevant aspects to this topic. And I think this is an incredibly important aspect that you are debating at the moment. And that's why I was really very pleased when you asked me. I only became aware of this development very recently, and then it was really with great pleasure that I accepted your invitation to talk today. Now, you asked me to do a few or give an overview of my what I've done, and I will do that in a moment. But really, it is an honor to present on this very important topic, a topical issue for such a distinguished South African and international audience. I know some of my own colleagues that I invited will also be attending, so it's just very exciting to have a group of South Africans and people from other jurisdictions to attend. Now, Anne-Marie asked me to just tell you why she asked me, and I was a little bit embarrassed to do this. But I think that I could very briefly tell you that I've got some expensive or extensive experience regarding the German board model, in particular because I've spent about 3 years in Germany doing research, first of all as an ordinary Alexander von Humboldt Fellow, and thereafter as the recipient of the Anneliese Meyer Research Award. I've published several articles, more than 120, and then I think you will also see that I'm the principal author of 3 very much corporate governance aimed textbooks, and one focuses in particular on the German model, the other one more on the Australian model and international, and then I've also published a book on disqualification of company directors. So all of that combined with several what I call highlight publications recently, I think I feel reasonably comfortable to talk about these issues. I've published some quite controversial articles, as you would see from the topics there. And it wasn't always easy to get them accepted for publication, because I am just really sort of getting outside the circle, as they say nowadays, and it's not always very pleasant for people to hear that we are moving in new directions. And when I start to talk about corporate social responsibility and directors' duty of corporate social responsibilities, people get quite nervous. I really want to tell you that all my views that I express here are only my own views. I'm not sponsored or paid to do the presentation. The views that I have, I've got no links with any political party in South Africa. My research is primarily based on my research and scholarly research. But, and I think this is important to note, I also have practical experience of sitting as the staff representative, having been elected by the staff members on the University Council, and our University Council also have the complete executive on it. So that has been a very interesting experience for me, and it would be great for me. I wish we had more time that I could share with you all the absolutely sometimes massive challenges that I experienced during that period. So let's just quickly have a look at the corporate law and corporate governance model underpinning the company law in South Africa. I really agree very strongly with the statement that Professor Michael Katz made when he said that, secondly, importantly, all the proposals that we are dealing with now, considered in this article, are made within the well-established legal framework and principles forming part of South African company law. It is further submitted that any implementation of the submissions contained in this article must be made within the architecture and structure of the existing legislation and common law principles which regulate companies in South Africa. To do otherwise would be subversive of the existing company law regime in South Africa with adverse consequences. My question is, but if legislation is required to make an arrangement mandatory, is it not impacting on the architecture and the structure of the existing company law legislation and company law principles of South Africa? And I leave this an open question. Could it not then potentially be and have adverse consequences? I want you to keep that in mind while I'm presenting in a very objective way. My view of the South African corporations law has been reflected in King 4, as you would know. That is the approach adopted by King 4, that in South Africa, the company is seen as a separate legal entity. And the directors in the company, this is all reflected in the quote from our article, Irene Marie Esser and my article, that's been adopted by the King Report, says that the directors owe their duties to the company, and the company alone, it is a separate legal entity. And I just want you to have a look at, to visualize how I see corporations law. So you've got a perpetual movement of the various stakeholders within this corporation. At one stage, it could be the clients that are dominant, and the directors must take their interest into consideration as part of the best interest of the corporation as a separate legal entity. The society or community may become dominant at another stage. Then the customers can become dominant. Then the government may have to be considered. And then, of course, the employees constantly. But whenever they act in the best interest of the corporation and one particular stakeholder or interest group is advantage over the others, then it must and can only be done in the best interest of the corporation. If not, then they would be liable for breach of their duties towards the company and to act in the best interest of the company or the corporation. And I think if you start to think about that principle, the employees has got incredibly powerful rights that they can enforce through the statutory derivative action in South Africa. I'll get to that later on. It's very important, and I know I'm taking you back to corporate governance 101 here, but to distinguish, which is still a vital distinction in corporate law and corporate governance and managerial circles, of the governance circle and the managerial triangle. So traditionally, we had everybody sitting on the board, not having any independence. They were part of the board, the governance circle, and the managerial triangle. Over time, we started to appoint more non-executive directors, not necessarily be independent. Then we started to appoint a majority of the non-executive directors to the board, and the majority to be independent. And then if we move to the right-hand side, this is the typical German two-tier board system where there's no overlap between the governance circle and the managerial triangle. And this is just a side note. If you want to put the South African close corporation into this model, this is how it will look. All the 10 members would be also managing the corporation, and that's why you depict it. So if we put timelines there, the traditional position was that all directors were also part of the governance circle and the managerial triangle. Then Cadbury started to promote the concept of non-executive directors. That has been expanded in other jurisdictions, like in Australia as well, adopted basically the Cadbury approach and the King approach. And then, of course, we know that the later approach was the majority of independent non-executive directors, and it's still the approach in the UK with the UK Corporate Governance Code. But Germany already adopted a long time ago the situation of a two-tier board system, but you must really realize that the move away, the governance circle away from the managerial triangle, has already been done a long, long time ago in Germany, but they did not include employees originally in the supervisory board. That was a later development. So perhaps we are moving back to the future if we start to think about how things happen over time. It is very important, I think, that you realize and appreciate what the German model is all about, because people immediately try to make analogies, but they don't really understand the significance of the German model. The German model has got a supervisory board, the circle there, and up to half of the supervisory board is appointed by members or by the shareholders. Between 1/3 and 1/2 of the supervisory board appointed by the employees. That's quite complicated. You can have a look at our German corporate governance textbook to see which industries are affected, and the various models. There are variations as to the number, the industries. But what is vital is the role of the supervisory board then, where the employees are sitting on, is to appoint the management board. But there's not generally any employees on the managerial board. That is vital to realize. It's also vital to realize that in the German model, very different from a unitary board model, there's a clear distinction statutorily defined between governance task and powers and oversight powers and managerial powers, and the one organ cannot interfere with that of the other organ. So the employee sitting on the supervisory board has got no direct say, has got no voice at the managerial board. They need to work through the supervisory board if they have any impact. The members of the supervisory board owe their duties to the company as a separate legal entity. So both the shareholder representatives, and I'm careful to use shareholder representatives, they have been appointed by the shareholders, but then they have their duties and owe their duties towards the company. The employees are appointed by the employee on the board are appointed by the employees, but they don't become the representatives there. They must represent the best interests of the corporation there. And originally it caused some concerns, but nowadays it's well established that they are aware how to distinguish between that. You cannot promote the best interests of the employees only at the supervisory board level. Otherwise, you would be liable for breach of your duty of care and diligence, as well as your fiduciary duties. And then the other very important thing is there's transparency between the two boards. You cannot be a member of the supervisory board and the management board at the same time, but they do communicate with each other. They do have sometimes combined meetings. They never take combined decisions, because then it would have an impact on the independence of the supervisory board and the independent oversight that they have over the management board. It's really important that you appreciate the position of employees here. They are never confronted with managerial decisions. They never need to take a decision that we are now going to sack half of the workforce. They never have to take decisions that we are going to close a plant, that we're not going to give the employees any rises of salaries. That is a decision by the management board and the management board only. So they haven't got a direct conflict of interest in that sense at all, which is massively different when you put an employee on a board of a unitary board. So let's unpack the South African model. No supervisory board, no duties towards the company, no employees currently appointing people to the supervisory board, no shareholders generally to appoint people to the supervisory board. They do not appoint the management board, and in actual fact, there's no sort of transparent relationship between the two boards. It's a unitary board. Now, this is an oversimplification. In actual fact, this is the situation that we have in South Africa and in most unitary board systems. The shareholders are responsible for appointing the board of directors. And then the board of directors would appoint, probably the red dot there, the CEO, which may or may not be a director of the board, and some of the other executives could be there, but it is primarily their task. So the current South African model for board level employee participation need to be considered very carefully. So we now we are going to deal with what are the possibilities. Where will the employee representative sit? First of all, how many will be appointed or directors by the shareholders? How many will be appointed by the employees? And exactly where in the governance circle or the managerial triangle will they sit? Now, I've given you three options here, and I have noticed that this has been debated. Two names came up, the views of Mervyn and the views of Michael. And there's sort of a little bit of confusion whether they could be considered to be executive directors or non-executive directors. So here, if you look at the two green dots, I've just plotted the two if we appoint two, because I get the impression that they don't want to have a lonely wolf sitting there. They need to have the employees to have at least some company and a larger voice. So we can say that both of them are non-executive directors. The lines start to blur depending on what type of employee you are if you've been appointed to the board. The second option would be to have one non-executive director and one executive director as an employee being appointed. How that's going to work is something that will have to be worked out in practice, or there is a possibility that you can insist that both of the employee representatives are executive directors. At what level? That's something that you'll have to sort out, or you'll have to work out exact rules that you don't want them at all to be involved in any managerial decisions or situations. So whatever model you adopt, wherever you put the employees that has been appointed by, or the directors who's been appointed by the employees, I've put all four there, but there will only be two at a time. They will face exactly the same problems in a unitary board system. They will have to take decisions and be involved in the day-to-day management of the company, in the sense that decisions are ultimately taken by the CEO and the management will have to be discussed at board level. The board must, including them, discuss very sensitive issues. They will have to discuss issues regarding the retrenchments of employees, etc., etc. They will be involved in these sort of decisions. So if I am a little bit skeptical about whether or not the unitary board with employees on a unitary board can work, should I immediately say it cannot work? And I would say without any doubt, the answer to that is no. And I'll give you 3 reasons why it could work. It's theoretically not impossible and also practically not impossible. And the first reason why I say this is, even in Germany, in one particular industry, the employees can appoint one person, what is called the personnel director, and that director sits on the managerial board. It's only one particular industry, and the issue there has been what would be the duties, and it's been clarified over and over that the duties are only to the corporation, not towards the employees. The person would sit there, have an idea of how management would deal with managerial or with employee issues, but cannot interfere with it, and just have got an oversight function and must act as part of the management board. So that's the one reason. The second reason is people tend to forget the Bullock Report 1977, where there has been in the UK in 1977 a proposal that they should adopt a unitary board with employees sitting on the unitary board. And I would really like to invite you. The report is not freely available. Fortunately, I could get a copy. The last time that I had a copy in the hand was in 1988 in the Institute of Advanced Legal Studies, and it was already put in the basement in 1988 because they thought, well, it's not relevant. But now it's relevant again. And please note that if you think that you thought about some original problems or advantages of putting employees on the board of a unitary board, just have a look at the Bullock Report. They've already dealt with all these issues. And if you look at the issues that they've dealt with and just the content, you will see all the issues that I've come across in everything that I've read about this proposal has already been dealt with to a large extent and in much greater detail than what I have read so far in the Bullock Report. All the objections have been dealt with, conflicts of interest, how you would probably solve it. The concept of that we are familiar with nominee directors. Why can't we get used to a nomination by the employees? That gets very complicated because who else should and must nominate then people to sitting on the board? But the point that I want to make is that, and this is very important, there was, however, also a minority report that was fiercely opposed to putting employees on the unitary board. They suggested a 2-tier board system in line with the German model. And they made it very, very clear that the unitary board system would not be an appropriate place to put employees on. And if you look at the committee's remit, they said that wasn't your task. And I just want to read the final sentence. The proposals in the minority report therefore represents, in our considered view, the best way of fulfilling what we regard as far from satisfactory or even wise remit by the majority. And I like the last 2 sentences, and I want you in South Africa to keep this in mind before you go ahead and adopt this as legislation. If the right solution can be found, the benefit to the nation, to industry, and the individuals will be enormous. But then misjudgment could lead to disaster. And please keep that in mind, and I'll make a few more comments. The third reason why I say that I cannot outrightly reject employees sitting on a unitary board. I've spoken to my colleague in Norway over the last few days, and this is apparently a system. I haven't got any in-depth knowledge that's been embedded for a very long time in Norway, and it seems as if it's working very well there. So I've got 2 of the hyperlinks there, and if you are interested, I would really suggest that you have a look of that. And I had a quick look this morning at the second one, the second block there in red, the box, the map of European industrial relations. That will give you a very nice summary of other models. But primarily, it's not the norm to have employees on a unitary board. So what are some of the reasons for concerns having a mandatory employee representation on boards? So I would think that you must appreciate that my own personal experience, having sat on the council where all the executives are involved, it's a challenging task. Perhaps it's because I'm quite well informed about directors' duties, and I know about conflicts of interest. I know about confidentiality. But I can tell you, I've also been a union member. And when I was on strike, my CEO phoned me and she asked me, I just want to hear whether my council members are on strike. I've not been on strike as a council member. I've been on strike as a labor representative. I never breach any confidentiality, but that sort of conflict and the constant fear, especially if you've got a strong CEO, of getting back to you at one or other stage is constantly there, especially if you are in a slightly higher position in an organization. Do not underestimate the consequences for the workers that's going to sit on that board. It's unavoidable that there will be tensions and animosities at the board level. I have experienced it firsthand when I wanted to promote something that I thought it was in the best interest of the university. And then the CEO would say, but well, that's not the direction that I would like to move in. I don't see it your way. And then immediately there's conflict. And eventually there is a very difficult task for the chair to make sure that there's no conflicts. Worker elected members, shareholder elected members, and non-executive directors, potential for conflict there. So there is a risk of an ununited unitary board, making the role of the chair almost impossible at times, in my view. And then based on all the above, of course, you would know that there will be tensions and conflicts also outside the boards between the worker elected members. At one stage, we were 3 members on the board, and we had discussions beforehand, and we started to differ on certain issues. That caused tensions. But then there were also tensions between us and non-union members, and also tensions between the trade unions and us, because they said, you are representing our interests. We said, we can't. So it's a very difficult position that you are in. And there are, of course, serious risks of legal liability for the worker elected members, as well as for the corporation, for various reasons. I'm not saying the same risks are not there if you haven't got employees on the board, but there's some connotation and some loyalty as an employee that is very difficult to make a distinction sometimes between what's in the best interest of your company and what's in the best interest of your union. When should you just, when you are briefed by your union or when you give feedback, when do you really give away some trade secrets of the corporation that can be abused? It's a very, very difficult situation. And I mean, I take it that there will be sophisticated and highly informed employees sitting on the boards of the unitary system in South Africa, that they would have proper training and they would be able to deal with these things. I found it quite difficult. And then, of course, I cannot emphasize enough, you need to think about the skepticism of your investors if you adopt such a model. I'll get back to this on my final slide. And then, of course, you need to consider the pool from which worker elected members will be elected. I know this should not be the ultimate deterrence of going into a new model. Over time, people will get experience and knowledge, but it's going to be an initial problem. You will have to have pre-appointment training and education, and then you'll have to have continuing education and training. All of these things, very constructive, very good. I'm not saying it cannot be done. In Germany, all the employee representatives must give a certain percentage, quite a large percentage, of the income or the remuneration they receive to the unions. And the unions then take them onto extensive training courses using that money on a regular basis. So it's a very highly sophisticated model of appointing employee representatives on the, or remember, on the supervisory board, and then making sure that they are well equipped for what they should and must do. So I'm not saying that that should be the model for South Africa, or that I'm saying you will require a similar type of thing to ensure that your employee representatives are up to speed with everything going on at a board and in business. Remember the Minority Report, the Bullock Report? It could lead to a disaster if you have this wrong. What are the existing protection of employees in South Africa? Is South Africa a legal model that where employees are deprived of remedies? Is this a jurisdiction where the employees really have nothing but to have a voice on the board, and that is the ultimate goal for them, and then everything would just be 100%? I have studied apart from being part of the process of the reform, I've been I've written several articles, and I've always been massively impressed with the ways in which, in a unique way, the interests of the employees are covered. There's no other jurisdiction that I'm aware of where the employees can bring a statutory derivative action. The influence and the impact that employees can have during liquidation, forming a committee, that we discussed in detail when these proposals were adopted. That right of employees do not or does not exist in other jurisdictions. The application by the unions or the employees to get another director declared delinquent or under probation, very unique. In the liquidity and solvency test, the employees must be informed. If there are related party transactions and there's loans to directors, the employees are informed. They don't need a voice or hear it from the board directly. And then, of course, the whole concept of employee shareholder schemes. And then you've got a seriously stakeholder-orientated corporate governance code, the King Code, which is most definitely an exemplar in the world as being stakeholder focused. So if you take all these things into consideration, I don't think that employees can sit back and say, well, you've really been trying to do us in. If you have, as boards of directors or companies, I can tell you then the employees must get their act together to sue the directors through a statutory derivative action by not taking their interests into consideration, because it's not in the best interest of the corporation. Why don't you do that? If you do that, then I think the directors will think twice before they ignore your interest. You've got the right to do it. Do it. Some additional practicalities regarding the appointment of employee representatives, and I've got only a few minutes left. Who else should have a vote on the board if you start to allow the employees in? Look at the other parties there. You will get pressure from other interest groups to have a voice there. And then the number of board members get out of hand. Will the provisions ensure gender diversity amongst the employees appointed to the board? Will there be a provision to determine from which levels of employees you will appoint your employee representatives? What happened or will happen to the collective decision making by boards? Will it really be not affected in a case where there are employees sitting on the boards? What will happen to the core principle that South African companies have total freedom to arrange their internal management in any way they want? And then I don't think that anybody that I've seen ask the question, well, these directors that's been nominated, appointed by employees, can you remove them under your section 71? So you will have, if you don't amend your Companies Act, directors that are irremovable. I think that is a serious problem that you need to think of. And then, of course, I've already mentioned the situation of expanding the number. So if we go back to what Professor Katz said, that we need to use the existing law, to do otherwise would be subversive of the existing company law regime in South Africa. Will it be? And I think it will have an impact. And then finally, I just want to ask the basic questions. There are massive international developments in this area after COVID, in particular. Somebody mentioned in one of the things that I read that while they referred to Larry Fink and the new American Business Roundtable approach as a justification now to appoint directors to the boards of South African unitary boards, I absolutely think it's wrong. Larry Fink or the American Business Roundtable never even suggested such a thing. They started to think about the stakeholder approach, something which the King Report started to think about in 1994 already, but they haven't gone any further but to move away from the shareholder primacy model to a stakeholder orientated model. But they've never, and you shouldn't and you cannot use that as an argument to have employees on your unitary board. And then absolutely over to Mervyn here, the massive developments over the last year regarding reporting on non-financial information. And I just want to once again remind you the concept of employees on board started with Bullock in 1977. Theresa May grabbed the concept, she dropped it like a hot potato, and you would know what the current provision is that the UK has got in their corporate governance code. So in conclusion, what is the real haste with this? Were other ways of addressing the problem really considered seriously and carefully? Is the architecture and structure of the existing legislation and common law principles which regulate companies in South Africa really be so flawed that fundamental law reform in this area is required? South Africa currently has got a modern and recently reformed Companies Act. It's got a modern and tone-setting corporate governance code. Focus on stakeholder protection. And then finally, and I leave this question totally open to those in power that not only will make the final decision, but also those who are instrumental of drafting the legislation for this. You will have to be responsible to answer to your employees, to your other stakeholders. How will the ultimate and current crucial stakeholders, the investors, perceive and react to a mandatory statutory requirement for employees, representatives on South African listed companies with a unitary board? I leave the question and the potential answer open to you. Anne-Marie, sorry, I've spent more time than I should.
John, I knew this was going to be a thought-provoking, balanced, objective approach, and I really do appreciate you taking and approaching it from that angle as well. This is but the start of a conversation. You know, as I've tried to say when we started, we need to engage, we need to talk about this on every platform so that we can get to the right answer, as you've proposed as well. So we're not going to have time today within the hour to get to the solution. I think it's the start. I would love for Professor King, just for 2-3 minutes. You've already moved in that direction around stakeholders, and I know he's got a particular view. He's the king of the stakeholder model, not only in South Africa but locally as well. Mervyn, just share with us in 2 minutes, please, your views, and then if you come online. Frick, I cannot for some reason see the chats today. I'm hoping you can, and maybe in the last sort of 7-8 minutes, if possible, you can just touch on some of the comments that were made in the chat. Thanks, Mervyn.
Thank you. Well, the question of the architecture of governance as laid down in our Companies Act and read with King 4 provides that directors are appointed by the shareholders, as Jean has correctly referred to. The proposal will not permit a veto by anybody of the person nominated by the labor union in the employee body. So not to have a veto, for example, the nominations committee would have considered the competency, the capacity, the credibility, the integrity, the experience of the person, and recommend that person for appointment to the board, and then of course it goes to shareholders in general meeting. That the shareholders, the proposal includes, John, an extraordinary proposition that no one and no body can veto the person nominated by the labor union. Now, some companies have 2 labor unions. There's not only one labor union. Secondly, this is not a question of employee representation. It's a question of labor union member representation. So it's part of that employee stakeholder body only that's being spoken about. And then they do, in my view, on this proposition, get foisted onto the board. Because if other stakeholders, particularly shareholders in general meeting, or the fellow directors cannot voice whether they think this person, for whatever reason, should not be a member of the collective mind of the board, then it's an extraordinary situation that you actually have someone foisted on you. So I've in the privileged position of having academic knowledge, but I've also sat on many boards in Europe, in UK, South Africa. And so I've got corporate scars on my body. I know that you sit in the boardroom and you have these conversations which are free-flowing, and you don't watch your language. You don't watch what you're going to say. You don't, you're thinking, and you blue sky sometimes in your thinking. And there's a free flow of conversation amongst board members. As soon as you have a position, which is part of this proposition, that the mandatory appointed labor union member will be entitled to go back and report to his labor union leaders what has happened in the boardroom. So you get the extraordinary position that you've got the Market Financial Act, which was based on the Insider Trading Act, which I chaired that commission, that if a director gives confidential information to an outside party, it's a criminal offense. Now, how do you overcome that by legislation? That's number one. Number two, I advised, and it was taken on in what was known as the Insider Trading Act, now the Market Financial Act, that there's a civil liability. So you've got proof of wrongful conduct by insider trading on a balance of probabilities rather than beyond a reasonable doubt being only a criminal offense. So Michael's answer to that was that you would have a non-disclosure agreement from the labor union members. But what control does the board have over those labor union members through a non-disclosure agreement? So you could have the extraordinary and unfortunate situation that our stock exchange would lose credibility, and that is not in the national interest. Forget about corporate interest. It's not in the national interest that our stock exchange is questioned as a capital raising platform. It's not in our national interest that outside investors, particularly foreign investors, of course local investors as well, are not satisfied that the price of a particular security on the exchange has been determined by pure economic principles of supply and demand, for example, but has been influenced by outside information and confidential information going to outsiders. I think the proposition taken as a whole can turn out to be absolutely disastrous, not only for corporations, but for the economy as a whole. So I don't agree with the proposition. I think it's poor governance, and I think it goes against the very architecture that Michael speaks about, and it will have adverse consequences. So I'm filled with concern about this proposition. Thank you, Anna-Marie.
Thank you, Mervyn, for sharing your honest view. Really appreciate it. It's all part of the debate that we really need to consider all of these potential intended and unintended consequences of ultimately really, engaging and increasing engagement with what is a very critical group of stakeholders. Frick, in the last 5 minutes, I'm going to ask you to maybe wrap up a little bit for us on the comments that came through, some of the questions, and so that we can let people off the hook by 1:30. Thanks, Frick.
Thank you, Anna-Marie. So I'm totally out of my depth with this conversation, so I'm not going to even try and answer these questions, but maybe I should pose them, and if between John and Mervyn they would like to maybe just give a quick response to that. Let me start with the last one, saying this discussion assumes a listed company. There's absolutely nothing unique about employee representation on boards in RSA. A myriad of entities covered in the sector supplements of the RSA Corporate Governance Code include employee representatives. That's the one. The other one say, yes, our architecture and structure of our legislation is flawed because it moved from an imbalanced base. And then I think it was part of what you said, Jean. The response here, litigation is very expensive in South Africa. It would be impossible for workers to sue directors. So I don't know if any of you want to respond.
John, maybe Frick, thanks for that. John, but you want to just share maybe your views?
That's I think I will leave it to Mervyn to respond to how many companies or organizations not listed would have employee representatives on it. I said very clearly that I don't see that it's necessarily a problem. I think there will be a different view if you start to talk about listed companies. That's the impact. That's what's driving the economy of countries. And I think it's more serious if you focus on that. That we started off on an imbalance, of course it's true. This is shareholder primacy model. I hope it's not going to be related to any sort of specific developments in South Africa as such, because South Africa did not get its own Corporations Act without a long history from America and the UK. So if that is in itself a problem, then we'll have to debate corporate law companies in a completely different context, which is not a debate here whatsoever, but it may be that I've lost track with the debates in South Africa. So if Mervyn would like to say something about employees on other boards.
Thank you. Mervyn, 1 minute, thanks.
The era of corporate leaders in the 20th century was to focus on the interests of the shareholder. It concerns me that by legislation we would have a focus on another stakeholder, and it's part of a stakeholder group, maybe the labor union members, not the employees as a whole, and give them the right of representation, mandatory, on the board without the necessary tests of competency, capacity, integrity, etc., and experience. And I think that's a huge concern. In modern governance today, a lot of companies today have an agenda item supply chain on their board, because companies have learnt that you can have a major supplier who may be using child labor, for example, and that will result in your company losing market value when that becomes known. On the trading floor, 40% of your market cap can be gone within 24 hours. So anything that is legislated or anything of this nature will not be confined just to listed companies, will be confined to companies, because if that is so, then the ultimate consumer listed company will have to look what's happening in its supply chain with SMEs and see that they are also compliant with this requirement to have employee representatives. The other thing that concerns me, as soon as you have employee representatives, by definition, to me, an executive director is someone that is contractually connected to the company and then takes off his contractual hat, puts on his statutory hat, becomes a director. He's an executive director. Now, Michael argues executive means senior management, but that was never the intention. Executive director is defined as a person who is an employee of the company and becomes a director. And so the labor union member is an employee of the company as executive director. You will have to then find more non-executive directors to balance your board. And the sizes of boards will just grow and the cost will grow. So for that reason, again, I think it's not a proposition that I favor.
Thanks, Mervyn. Jean, from my side, and I know I'm speaking on behalf of Frick as well, again, thank you so much for sharing some of your very valuable and, experience and really, giving us some very good pointers and putting us in the direction of some material we can also read up more. So that I think, and I think that's, what we need to do is look at the what it is that we're trying to achieve here and see how best we can do it in the interest of, and I think this is what Mervyn is trying to say, and without me putting words in your mouth, Mervyn, in the interest of South Africa Incorporated, because a successful South Africa will ultimately have a benefit for society as a whole, and that is what I think, we need to strive for, everyone. On this call today, everyone walking the corridors of corporate South Africa and sitting in the boardrooms of corporate South Africa as well. It's 1:30 from my side on behalf of SGI, Fluid Rock. We thank you for your participation. We hope it was as a start, as a conversation, that it gave you some food for thought, and definitely we will reconvene on this topic in the coming months to extend our debates and our discussion. So I thank you very much. Thank you, John. Have a good night's sleep. Thank you for joining us in the evening in Australia. Sleep well. Others, for those of you still in the office this afternoon, good luck. Hang in there. The clock is ticking, and soon, we will we'll also lock off like. Thank you, Mervyn, for your input, your time. Really appreciate it. Have a good afternoon, ladies and gentlemen. Thank you.
Thank you.
Thank you very much.
Thank you very much.
Thank you, Mervyn.